Okay, good morning.
Morning, Your Honor.
We're here on the case of Yeager versus Wyndham, and we also have scheduled at 11 o'clock the case of Brower versus Wyndham. So I did want to ask you about the possibility, since there's so many overlapping issues and so many overlapping facts, of doing a single argument and perhaps getting a little more time than the 20 minutes aside. What's y'all's position on that?
Your Honor, I'm happy to handle it either way, whatever you prefer, the judges prefer. Had prepared, to address the facts of Brower separately, but certainly it's right after this one, so prepared to handle it either way.
Okay, Ms. Turner?
I'm prepared to argue jointly if that would be more convenient. I think that it might be a waste of time to do them separately.
Do you want 25 minutes each then, or does that work?
That works for defendants.
Or Mr. Curry, or do you want a little more time?
I think that's fine, and maybe we can just see how it goes.
Okay. We'll do that. Let me go ahead and Judge Evander, I'll be presiding over these arguments. I'm joined on the panel by Judge Jim Edwards and Judge John Harris. These oral arguments are being live streamed and also recorded. Mr. Curry, we'll set the clock for 25 minutes now. How much time do you wish for rebuttal?
I'll reserve 5 minutes for rebuttal, Your Honor.
Okay, there is a clock on the screen, but I'll try to help you in that regard as well. And with that, you may proceed with your argument.
Thank you, Your Honor. May it please the court. Lance Curry here on behalf of the appellant, Janet Yeager, who is the personal representative of the estate of Mr. Ernest Yeager and the trustee of the Yeager Living Trust. Also, Mr. Yeager passed away in July 2020, shortly before the court entered summary judgment in that case. And also here on behalf of the Brower appellants and the Bargee Corporation. We're asking this court to reverse the final judgment that was entered in Wyndham's favor because Wyndham failed to conclusively establish that the Yeagers and the Browers' claims are barred by the statute of limitations. And we've essentially raised three issues in our brief. The first is that several of these claims simply cannot be time barred because they didn't accrue until within 4 years within the limitations period. The second issue that we raised is there's a jury issue as to whether the continuing tort doctrine applies given the facts of this case. And the third issue is whether there's a jury question as to whether Wyndham should be equitably stopped from even raising the statute of limitations given the conduct in this case.
Let me ask you about the equitable estoppel argument. The equitable estoppel suggests that you were lured somehow into not filing a complaint. So it's, and I mean, it seems undisputed that complaints were filed in Alabama in 2011. So between 2011 and 2014, that time period, it seemed to me pretty hard to argue that you were somehow lured into not suing when you had sued.
Well, yeah. So I think what we're arguing is that although these clients did not know until 2011 that Wyndham had this hidden plan to shut these businesses down, to prefer its own interests in favor of the owners, they did know that there were certain representations made to them that had been breached back in 2008. There were certain promises made about certain benefits not changing. And by 2008, those benefits did change. And so the equitable estoppel is really at that point in time, they didn't sue on those representations that were breached in 08 and 09 because there were statements made that lulled the plaintiffs into believing that Wyndham was going to make it right, that Wyndham was going to fix those problems. And that if they had done.
But in 2011, they knew of information giving them the right to sue. They could have sued in a Florida Circuit Court at any time between 2011 and 2014, correct?
They could have. That's correct.
All right.
they tried to join these cases in Alabama because there were already pending lawsuits there, and that's where they learned about the truth behind what Wyndham was really up to. And when the case was actually filed in the court below, and Wyndham removed it to federal court, when Judge Conway sent it back, she actually applauded the plaintiff's effort to try to join the case in the Northern District of Alabama because it could have, preserved judicial resources and the like. But it really gets down to we did file the case below on July 29, 2014. So the question is, what happened within the 4 years before, depending on the claim, but most of these claims are governed by a 4-year statute of limitations. So is there record evidence showing that the plaintiffs, and I'll start with Mr. Yeager, that Mr. Yeager suffered harm from Wyndham's alleged misconduct on or after July 29, 2010? And the answer to that question, Your Honor, is undeniably yes. Mr. Yeager testified that he was able to continue operating his business until Wyndham shut him down in late 2011 or early 2012. He testified that in 2011, he was still running his business and making money. He made money running his business until the day Wyndham shut him down, which again was late 2011 or 2012. And during the last 6 months of running his business, he started losing reservations due to Wyndham's changes to his ability to cancel and rebook reservations, which was a perk that was sold to Mr. Yeager and to the Browers as part of their VIP benefits. It was taught to these plaintiffs by Wyndham's own employees. And Mr. Yeager testified that the big one that damaged his business, that's his quote, the big one that damaged his business was the cancel rebook change from 2011 plus. Now, Mr. Yeager knew earlier that certain changes had been made, but he did not know that these changes were being made by Wyndham in an effort to shut these businesses down, in an effort to prefer Wyndham's own interests, its own rental company that it had extra holidays, instead of the owners. 2011
is there motivation of why they were doing these things that harmed your clients? Is that an element of the cause of action?
Well, it's not an element of the cause of action, but for example, Your Honor, in breach of fiduciary duty, if there's a fiduciary duty, obviously a breach occurs when the claimant is preferring their own interests over the interests of the fiduciary. And so the claim here is that within the 4-year limitations period, Wyndham was absolutely breaching its fiduciary duties by preferring its own interests, its own financial interests over the owners, and causing harm. So the accrual is the causing harm at the time that they've actually breached their fiduciary duty. And that's exactly what the facts.
Right, but you don't need to know why they were doing it in order to show the harm. You could show the harm. We were promised this. They kept telling us we could do the cancel rebook, the unlimited bookings, no booking fees, all the other things that happened that then got changed, which harmed your client's business. You don't need to know the motivation for that in order to have a cause of action, correct?
That's correct. You have to know that you were harmed by it. And then in order to assert a breach of fiduciary duty claim, you have to know that they actually are breaching the fiduciary duties by preferring their own interests. And then fraudulent concealment claims, obviously a little different, and I can talk about that as well. But the allegations and the evidence, record evidence, support that there was breaches of fiduciary duty. There were violations of the Florida Timeshare Act that happened after, for Mr. Yeager, July 29, 2010, and for the Browers after August 11, 2010. And that those breaches of fiduciary duty, those violations of the Timeshare Act, damaged these plaintiffs after 2010.
Are you viewing the elimination of the cancel and rebook benefit as a distinct and separate act, which would statute of limitations on the breach of fiduciary duty would start within the limitations period?
Yes, Your Honor. It is a separate breach of fiduciary duty, that conduct and limiting that. It is a separate violation of the Timeshare Act. Now, the question becomes that we can get into continuing tort, whether
Right,
it's-
I was just going to say, doesn't that kind of work against the continuing tort argument if we treat this as a separate and distinct act?
Well, if you look at the case law dealing with continuing tort, you can tell that the courts sometimes struggle to apply the continuing tort doctrine and how it applies to certain facts. And I thought the Winn-Dixie case from the 11th Circuit, 2014, that's cited by both Wyndham and us in our briefs, I thought they phrased how to apply that test well. And what they said is it's essentially two questions. The first is whether any acts took place during the limitations period, and then if so, whether those acts were substantially similar to qualify as continuing the prior events. And the court recognized that that's ordinarily a question for the jury. So while that conduct after 2010 in canceling, diminishing cancel rebook, they also changed the official rule book of the Club Wyndham Plus program. In doing those things, those were acts that were separate grounds for a breach of fiduciary duty claim, separate claims for the violation of the Florida Timeshare Act. But were those acts also substantially similar to the prior acts enough to raise a jury question?
Well, could Wyndham have canceled the cancel and rebook benefit, eliminate that without doing all the things they did in 2008 and 2009? They could have chosen to make that the only change, correct?
They totally control the rules, so they can change them however they want.
And can a court determine as a matter of law that that is a separate and distinct act and not have it go to a jury?
Well, I think for the purposes of the continuing tort doctrine, that it really is. I mean, the case law is clear that in this context, when you have something that does happen in the limitations period, and whether it is substantially similar, it raises a question for the jury to decide. Now, I guess if your question is, if that was the only thing that they did way back in 2008, would that bar us from raising?
No, I'm saying if that was the only thing they did in 2014 and never, in 2012 and never did those things in 2008 and 9, that could stand by itself, right? I mean, it's kind
I
of
believe that's correct. It's an action that takes place within the limitations period. And I think what you're really looking at is whether those acts before the limitations period, are those discrete events, or are they related to the events that took place in the limitations period? And if you look at the case law that we cited from Florida, the Hawkey Roberts case from the second DCA.
Yeah, but that's why I asked the question. You said they're related, but I'm trying to figure out the difference between related and distinct. And it seems to me if they can do that one act in 2012 on the cancel and rebook and not do the other ones, I don't see that. I'm trying to find a continuous flow, which would seem to be required by your argument on the continuing tort, as opposed to them just making 3 or 4 changes to the detriment of your client. And those changes all affected your client in different ways. And so that's the problem I'm having on your continuing tort argument, is it seems like there may have been one intent to harm your clients, but as Judge Edwards pointed out, that's not an element. And if there's 3 or 4 distinct acts that all could have been done separate of the other and were not part of one continuing act, then I'm having trouble on your continuing tort argument.
Your Honor, what I would say is certainly there were different rule changes. It was the death by 1,000 cuts, right? Different rule changes that took place. The real question pertinent to the continuing tort analysis here is, why were those changes made? Keep in mind that Wyndham's message to the owners throughout this was, these are being done, these changes are being made in 2008 and 2009 for the betterment of the program overall. There was never any statement to these owners that, hey, you can't do this. If you keep doing this, we're going to shut you down. And there was certainly no acknowledgement that we Wyndham are doing this for ourselves to put more money in our own company. So when you're analyzing the question of the continuing wrongful acts, the real question is, why were they doing it? Were they doing it to breach their fiduciary duties and violate the Timeshare Act by doing it to prefer their own interests?
Well, even if the intent's the same, let's say in 2009, you don't like someone, you punch them. In 2010, you still don't like them, never have, and you punch them again. In 2012, you still don't like them and you punch them again. Is that one continuing tort or is that three separate batteries?
Well, I think in that context, it would be three separate batteries.
Even
Because,
though the intent's the same, that
Well,
you don't
the-
like
yeah.
them and you want to cause them physical harm.
right, and there's clearly no hidden intent. There's clearly no acknowledgement that we are actively doing this for our own purposes and hiding and concealing material information about what's going on behind the scenes. And that there's this ultimate goal that we are going to change the rules to shut you people down. We're going to make some changes, and you might not like all the changes, but it's okay because they're for the good of the program. They're for the good of all of the owners. And what these clients came to learn in 2011, and part of it is when the official rule book, the member directory is changed, they come to learn is that Wyndham is not actually making these changes just to better the program. They are making these changes to shut these people down, even though they keep telling them that they encourage the rental business, shut these people down and do it to prefer their own interests and put more money in their own pocket with their own rental company, extra holidays competing against them. When they made that change to the rule book in 2011, it was a really meaningful change because when a buyer buys a timeshare from Wyndham and they want to participate in the Club Wyndham Plus program, they have to assign their timeshare interest to the trust. All of the documents say there's a trust agreement that governs it. And that trust agreement specifically says that the rules, regulations, guidelines, policies, and procedures related to the use of points by members are fully described in the directory, and that the information in the directory shall be controlling. That's on page 459 of the record. Well, prior to 2011, there were no Club Wyndham Plus rules that precluded rental for commercial purposes.
Let me ask you this, was there anything different in the change to the membership directory that wasn't in the party's original contract?
Well, the party's original contracts in buying an individual timeshare reference things like there are no representations being made. I mean, there's a ton of fine print, as you might imagine.
Right. But I'm just asking on the part about the commercial use.
Yeah, and it does say that the individual contracts say that this purchase is for personal use. But those individual contracts are not the rules of the Club Wyndham Plus program. And they do not establish the benefits that are given to someone who assigns multiple timeshare interests for millions and millions of points as to what their benefits are. That is defined by the trust agreement only.
So my question is going to the issue of if you say something to a person outside the time limitations, then you repeat it inside the time limitations, is it actionable or are both actionable, or how does that work?
Well, it depends on the claim, I think, to a certain extent, but let me talk about the fraudulent concealment claim in particular. That claim accrues when the plaintiff knows or should have known that Wyndham was fraudulently concealing material information about what it was doing and why it was making those changes. So the plaintiffs knew that certain changes had been made that were adverse to their business, but they had no idea why. That Wyndham was up to this, that Wyndham was secretly trying to put them out of business. And again, Wyndham never said, you can't do this. We're not going to allow you to do this anymore. We're going to shut you down. So while Wyndham was finding ways to benefit itself, it was telling Mr. Yeager, for example, everything's going to be taken care of. These are just internal problems, and his benefits would be reinstated. They were doing that all the way up to 2011, according to Mr. Yeager's testimony. So those are statements that are being made within the limitations period that are material statements that do not disclose the full picture of what's going on. Had Wyndham said, look, we're making changes to this program because you guys can't do this. You cannot operate a rental business. Your original contract said personal use only. You can't do this anymore. Had they done that, our claims would have accrued right when that was taking place. But Wyndham didn't do that. Wyndham continued to work behind the scenes. All of this information that we've discovered about what Wyndham was up to, how it was preferring its own rental company to the interests of the owners, was discovered through the litigation. I mean, there are things that they're doing even as late as 2016. They talk about how this cancel rebook issue is just a loophole and that, you know, it was never a benefit for any of the owners. And yet the senior vice president of product integration, product development and integration is sending an email in 2016 saying, hey, we need to wean the salespeople off of using the cancel rebook park in their presentation. They know that their own employees are using these promises, these statements to induce people to pay, and yet behind the scenes, hidden from the owner base, they're making changes to the program, and the real critical reason for these claims is why. Why is Wyndham doing it? If it's truly doing it only for the good of the program, only for the good of the owners, then we're going to lose. But if a jury believes that Wyndham was doing this because it was preferring its own interests, then we will prevail on breach of fiduciary duty, the Timeshare Act, fraudulent concealment, and the like. I do think on equitable estoppel, to come back to that real quick, Your Honor, there is a jury question on whether they should be equitably estopped based on their statements to the plaintiffs saying, hey, look, everything's going to be fixed and everything's going to be made right. And that's a fact issue. We cited a number of cases in our initial brief and also in our reply brief that recognize that that issue is a question for the jury to decide. Wyndham hasn't cited any authority to the contrary. Now, the trial court, what it said was there's, quote, no valid basis to grant the relief requested, but that's not a decision for the trial court to make. We're not asking the trial court to grant that relief. That's a question for the jury to decide.
All right. We're down to 4 minutes and 20 seconds. Wish to reserve the remainder of your time?
Yes, Your Honor. Thank you.
All right, thank you. All right, Ms. Turner.
May it please the court, Sarah Turner here on behalf of the appellees, Wyndham Vacation Ownership, Wyndham Vacation Resorts, and Wyndham Vacation Management. For the purposes of this argument, I'll refer to the three defendants as Wyndham, although they each have distinct and separate roles, but because that's the way they have been referred to throughout this argument, as well as in the pleadings themselves, that's how I will refer to them for this argument, because I don't think ultimately it matters in terms of the issues at hand. Both the Browers and the Yeagers were sophisticated commercial parties. The Browers and the Yeagers had each been longtime real estate investment business owners. Mrs. Brower is actually a real estate broker. These were people who were used to dealing in this very area of business. And when they made their purchases and decided that they were going to enter into commercial timeshare rental, they believed that they had been represented that there would never be any changes to the CWP exchange program that would in any way harm or negate the profitability of their business. There's no question that at least by 2008, they were aware that those types of changes could and would be made, that they would be applied to them and their businesses, and that they would be impacted potentially negatively by those changes. In addition,
Let me ask you this. The trial court's order talks about what you just mentioned, but would you agree that the statute of limitations period accrues at a different time for breach of fiduciary duty than for a fraud claim?
Sure. So sorry.
Because breach of fiduciary duty is when the damage occurs from the breach, Whereas fraud, I think the reference is when you discovered or should have discovered facts giving rise to a cause of action with the exercise of due diligence. And I don't see anywhere in the trial court's order where the trial court analyzed those differently. I mean, I see the analysis on the fraud, but I didn't see any analysis on the breach of fiduciary duty as far as having a different time where it accrues. So would that be a fair assessment of the trial court's order?
So I think that there's two distinctions that I would make. That first, I think we need to look to the trial court's order where Judge Jordan indicated that one of the bases of his decision is the fact that the plaintiffs voluntarily continued to do business with defendants even after they knew of these types of changes being not only negative to their business, but also the fact that they no longer trusted Wyndham to the extent that they ever did, right? Both the Browers and the Yeagers. For example, the Browers were saying things like, warning other people you need to use due diligence when you're engaging in transactions with Wyndham, a recognition that any of their benefits could be changed, that any promise could potentially be rescinded, that their ownership was only worth pennies on the dollar, and that they voluntarily continued to engage in the business with defendants. But I think more significantly, if you look at when the actual damage occurred, based upon what I think is the real breach, which is, or the real alleged breach, which is simply that changes could be made that would impact their business. And when were they damaged by that? I think they were damaged by that on the day that they made their purchases, and that isn't what they actually purchased. Similar to, I think, this court's decision in Black Diamond. The day that the damage actually occurs is the day that they purchased something that isn't what they thought they were getting. So in this case, plaintiffs thought that they were purchasing, under their allegations, a timeshare interest that they were going to be able to assign to a trust that was forever going to be profitable until the end of time, that they would forever be able to run profitable rental businesses, and that no one would ever do anything to change their ability to do that. And once they made the purchase, and that isn't what they purchased, right? They purchased something else, is the day that they were damaged. So I think it's possible that the first day they were damaged is the day that they entered into the contracts, which say that they're making purchases for their personal use only and not for any commercial purpose, because they purchased something that wasn't what they were allegedly promised. That being said, with respect to the actual individual breaches of fiduciary duty, talking about kind of the three remaining breaches that the plaintiffs now allege took place somehow after the 2010 time period. I think that the court's order deals with each of those individually, in that, for example, cancel rebook. The court obviously had lots of summary judgments and lots of evidence before it on the day that these were argued. But with respect to the cancel rebook change and whether or not that was an independent breach, that was a separate summary judgment that was brought. Defendants brought motions to dismiss on those grounds, saying that there hadn't been a fraud or a tort that was pled as to the cancel rebook allegation. Defendants brought a summary judgment as to the cancel rebook allegations. Defendants raised that argument as to plaintiff's motion to amend to add punitive damages. And in response to each of those instances, when defendants raised the fact that a cancel rebook had not been pled as an independent tort, the plaintiff's response was to say that cancel rebook is not an independent and separate claim that we are bringing. It is simply evidence of the claim that already exists. And I think that is in part why Judge Jordan didn't need to address that as a separate and distinct tort, because that was never alleged, and on appeal is the first time that that is being argued to have been something separate. The plaintiffs are the ones that get to control their pleading. They are the authors of how they choose to plead their case. And in this instance, plaintiffs intentionally chose, after This is the 7th, I guess, pleading just in Florida, but it's, I think, the 13th pleading that they've made overall. We've been in Missouri state and federal court. We've been in Alabama federal court. We've been in Florida federal court. And in all of those pleadings, plaintiffs never wanted to bring cancel rebook or the change to the members directory or the use here as separate independent tort claims. Instead, they wanted to bring them as just additional evidence of part of an underlying scheme. And the underlying scheme that they allege is that they thought they were purchasing something that they were going to be able to run a profitable business for the rest of eternity. And as soon as they knew or were on notice that they weren't going to be able to do that, or for the breach of fiduciary duty and statutory claims, as soon as they knew that they were damaged, i.e. that isn't what they had purchased, that they didn't purchase the ability to run a profitable investment business, rental business forever, those claims had accrued. And so I think that the reason Judge Jordan doesn't address that with more specificity is because the plaintiffs chose not to bring those things as independent torts in their pleadings. And time again, the lawyers disavowed that. If you look to the transcript from the summary judgment hearings that took place on the day that that this one did, I believe it was Mr. Curry that argued and said that the cancel rebook was not being pled as an independent tort. And in fact, in response to one of the motions to dismiss that was filed, if you look at the Brower sealed record on page 1692, the plaintiffs actually went so far as to say that the damages that had occurred were also stemming from the earlier breaches, the 2008, 2009 breaches, that is when the defendant's businesses were crippled. And so the damage, I believe, predates. And I think the reason Judge Jordan didn't deal with these things more specifically is because they hadn't been pled as separate claims. I did want to touch on the equitable estoppel argument that Mr. Curry spoke about. And I think that as this court found in Black Diamond, the equitable estoppel argument presupposes that the plaintiff already knew the facts that were underlying their cause of action, but delayed filing suit purely because of something that defendants did. Here, the plaintiffs are saying that they didn't know about their cause of action. And so that is an affirmative representation that they've pled and that they've made. And so even though they knew that they were damaged, they're saying that they didn't actually know that they could bring a cause of action until after they had actually filed their first lawsuit in Alabama. And just like in Black Diamond, the plaintiffs here argue that they didn't discover their suit until after 2011, which is ironically after they had already filed their first lawsuit. But and so as a result, they can't rely upon equitable estoppel. But just because they can't rely upon equitable estoppel doesn't mean their claims can't have accrued. In this case, it almost seems as though the plaintiffs are attempting to use their fraud in the omission claim as an end run around Florida's equitable estoppel argument or law, which is very clear that equitable estoppel can't be used to toll a statute of limitations unless you fall under the specific statutory provisions, or if you are dealing with a specific circumstance like child sex abuse or something along those lines. And so in this instance, the fact that they were ignorant of, or they claim that they were ignorant of their causes of action doesn't allow them to use equitable estoppel as an alternative argument. I also wanted to touch briefly on the assignment agreement issue, which is the provisions that are between or that were in the contracts versus what was later added to the membership directory. The provisions that are in the contracts are nearly verbatim to what is in the membership directory. The contracts themselves simply say that the membership directory is incorporated by reference as part of the contract. The assignment agreements that the plaintiffs signed, they had to initial next to a specific line on the assignment agreement that says that they were making their purchases for their personal use only, that they were not making the purchases for the purposes of any investment vehicle. And that is something that has always been part of the rules of the road with respect to these contracts. That wasn't something that was a new change.
Ms. Turner, how can Wyndham see, for example, the Browders, I believe it was, purchasing 1 million points and say, oh, that's for your personal use? I mean, that makes no sense to me. They knew what was going on, and they closed a blind eye to it and didn't change the rules till later. I mean, that's if they were buying 50,000 points, something like that, you might think they're going to have a wonderful year's worth of vacations, but 1 million points, there's no way they're using that for their personal use. So how do you ignore that in the whole scheme of things?
Sure. So first of all, the Browers didn't purchase that many points from Wyndham as opposed to on the resale market. And so they are making the vast majority of their purchases on the resale market. But even assuming that Wyndham knows or can see that they're assigning these contracts into, or these additional points into the trust at large volumes, and assuming then that Wyndham thinks that they can't be possibly using it just for their family and friends, they've got to be using it as a commercial business. Even if those things are all true,
they knew they were tracking mega renters, so it's not so much of a hypothetical assumption that they knew what was going on, right?
Well, I mean, I think at some point in time, I don't know if I would use the word tracking. That's obviously the language that the plaintiffs have chosen to use, but certainly at some point in time, it became clear that there were a group of owners that were taking advantage of the rest of the members of the trust, doing things like blocking massive amounts of inventory and then canceling it at the 11th hour. So the inventory would go dark. So the other members of the trust couldn't use that inventory. And so to the extent Wyndham develops changes, or it's not even Wyndham, it's the board of the CWP that implements changes in order to protect the other members of the trust, which is their duty to do, that then somehow certain members of the trust who were the ones taking advantage of the trust in and of itself can then complain and say that now that these rules are being enforced in a way that I don't like, or being changed in a way that I don't like, that somehow I'm now able to complain about that. I think the other thing that's in the contracts is the contracts clearly say that the rules can be changed at any time. You don't have to assign your timeshare interests into the trust. That's something that's voluntary. You could just make your purchases and use them outside of the trust. Once you've voluntarily put it into the trust, the advantage is that you can use your points to make reservations at lots of other places. The disadvantage is that you are then tied to all of these other people as part of an exchange program. And so the exchange program is going to be run in a way that isn't that can't give advantage to particular owners over other owners. It has to be run in a way that is, protecting the best interests of all of the owners. And so that's another issue that, based on what we have before us today, I don't think you can tell what specific actions plaintiffs are alleging defendants took that would have violated the Timeshare Act, for example, or would have breached a fiduciary duty. I know that that's not what we're talking about today, but those were certainly issues that were argued before Judge Jordan that he mooted for the purposes of this because he thought that the statute of limitations took those claims out. But there's no question that both the Browers and Mr. Yeager were well aware that the changes that were being made by Wyndham were changes that were going to be harming them. And moreover, that they no longer trusted Wyndham. And so to the extent that plaintiffs are arguing that somehow representations that were being made by defendants were lulling plaintiffs into, or the appellants into not filing a suit, it's obvious based on the written record and the evidentiary record that both the Yeagers and the Browers didn't believe anything Wyndham said for many years before 2010. Mr. Brower was saying things like, you need to use your due diligence in dealing with Wyndham. He said that he went to timeshare pitches to try and just so that he could see all the lies that the Wyndham sales representatives were telling other people. And those were the types of things they were saying all the way back in 2008 and 2009. They weren't in a trusting relationship with Wyndham going back even that far in time. Have I answered your question? Okay, thank you. With respect to the intent and continuous flow arguments, I think I did want to just briefly touch on the intent, because I think the court is right that that intent is not an element of any of these claims. I also think that with respect to a similar intent, just because whatever the intent was, just because different actions might have a similar intent does not make them one continuous tort. To the extent that plaintiffs wanted to allege that these three separate actions that they're now hanging their hat on, first Usier, which ironically was also brought as a breach of contract claim, only in the Brower case, Usier only applies to the Brower case, was brought as a separate breach of contract claim, which plaintiffs then abandoned in order to bring this appeal. They actually prevailed on that in front of Judge Jordan. And now they're saying that it's also a fraud claim or as part of their other claims. And then with respect to the cancel rebook and the addition of the language or the cutting and pasting of the language from the contracts into the membership directory with respect to personal use, even if those things had similar intent as to the prior actions that had been taken, doesn't make them one continuous action. If plaintiffs had wanted to bring separate causes of action as to cancel rebook, Usier, and the change of the membership directory, they could have done that. And they intentionally chose not to. And defendants raised that issue time and time again. And plaintiffs affirmatively said time and time again that they were not bringing those as separate claims. They said these are not claims. These are mere evidence of the claim that exists. And the claim that they said exists was an overarching scheme to make it so that the defendants, or excuse me, the Browers and the Yeagers could not run a profitable rental business. It's clear that the Brower and the Yeagers' ability or that defendants or that Wyndham's actions, which might impair their ability to run a commercial rental business, were things that took place long before 2010. And that at least the plaintiffs believe that to be the case.
So, Ms. Turner, just so I'm clear, is it your argument that the plaintiffs made a tactical decision to not allege separate incidents, including post-2010, in order to arguably strengthen their argument as to the continuing tort?
Yes, Your Honor, I think that that is exactly the strategic decision that they made. I also think that the three items that we've been talking about, the cancel rebook, the change to the members directory, and the UCR aren't particularly strong claims. And so they don't have strong damages elements. Those were things that we raised at summary judgment. There were not representations made to these folks related to those claims. And I think that from Judge Jordan's perspective, when he was writing this opinion, he believed that the fact that the trust relationship had already so clearly broken down such that there couldn't have been any reliance upon any separate representations that were made pursuant to those claims, that he didn't think that those claims could survive a statute of limitations, which is why I think he didn't separately address them. But I do think that it was a strategic choice not to bring those claims separately, both because of the continuing tort, but also because I think legally those claims don't have any merit. And we've talked about some of the reasons that those claims would fail otherwise.
Okay. Any other questions from the panel members? All right. Thank you. Mr. Curry, Rebuttal, you have 4 minutes and 14 seconds left.
Thank you, Your Honor. I'd like to address the question Judge Edwards raised first about Wyndham's knowledge of all these points. The Browers did, in 2005, they bought 1.8 million points directly from Wyndham for $143,000. At that time, Wyndham's own internal documents, we came to learn, say that they currently support owners running rental businesses. And that in 2009, the Mega Renter Project said Wyndham has been selling more points to an owner who already had millions more than they could personally use. These are Wyndham's own internal documents. And then they say, well, we're going to make some changes to the program. And internally they say, let's make them to appear to affect the entire owner base so as to accomplish, quote, perceived improved equity. They're doing this to make it look like we're just doing this for the program and the owner base, and they're really attacking these folks. I'd also like to address the issue of that these claims are absolutely different. The judge's order below focused almost exclusively on fraudulent inducement, the fraudulent inducement claim. The breach of fiduciary duty, Timeshare Act claims are different claims. Every time Wyndham breached its fiduciary duties to these owners or violated the Timeshare Act and caused them harm, that's our element, our accrual. Every time they did that, a new cause of action arises that they can pursue. And that's exactly what has happened here. What Wyndham is really doing, and you can hear it in the argument, is they're asking this court to consider all of the evidence in a light most favorable to Wyndham. Under this court's decision in the Baxter v. Northup case from 2013, Wyndham had the burden to conclusively show that there are no fact issues regarding statute of limitations, and that the evidence must be considered in a light most favorable to these plaintiffs. And if the, quote, slightest doubt exists, summary judgment must be reversed. And I would submit that there's all sorts of doubt on this record as to whether all of these claims should be barred. There's doubt on accrual, there's doubt on the continuing tort, and there's doubt on equitable estoppel. Mr. Yeager didn't even know he was a mega renter until 2011 when he met with these folks, with the lawyers. This idea that we didn't bring a cancel rebook claim or whatever, we don't have to bring a cancel there's no such thing as a cancel rebook claim. We allege in our complaint that Wyndham violated the Timeshare Act by eliminating Yeager's right to use the cancel rebook perk. That's a very specific allegation in our complaint. We allege that they breached fiduciary duties by creating and implementing rules that were secretly developed to increase Wyndham's profits. We alleged these claims, Your Honor. Real quick, the Black Diamond case that they mentioned, in that case, it dealt with a single claim, a statutory misleading advertising claim. That the misleading advertising there that caused those plaintiffs to purchase happened well before the limitations period. There was no cause of action in that case regarding ongoing breaches of fiduciary duty, ongoing breaches of statutory violations. I would like to leave the court with the Hawkey Roberts case, which I believe is as close to on point as we get. In that decision, the second DCA reversed the final summary judgment for the defendant based on statute of limitations. It involved a corporate plaintiff suing its former president for breaching fiduciary duties by using corporate funds for personal, political, and religious interests. It's similar to what we have here. We're suing Wyndham for misusing its power for its own financial interests. And the court there said, you can't throw all of these claims out because some of these alleged breaches of fiduciary duty that caused harm, some of them occurred within the 4-year limitation period. And then the court goes on to say, and what we've got here is a jury question regarding the continuing tort doctrine. Some of these breaches of trust in preferring their own financial interests over those of the corporate plaintiff in that case were continuing on back before the limitations period. So it was a question for the jury to decide. If the court doesn't have any questions for me, I would ask that the court reverse and remand for further proceedings so that the jury can consider these questions regarding accrual equitable estoppel and continuing tort.
All right, thank you both for your arguments, and the court will be in recess.
Thank you.
Thank you.